which is the next page in my binder that was given to me.
I wish they would have it that way. Because I do think it's confusing. But since I've already given it, I'll just swap in 3903 and 3903A as already read. Because I did already read these.
Oh, so you're going to keep the one that's been read already? Is that what the court is saying?
I did give these jury instructions, I gave them as they're printed out here. It's just without the, I think the proposed instructions had language that I struck out, so this is just a clean read.
The one that I submitted this morning is directly out of KC.
But you combine 3903 and 3903A. And that's not how I gave it. So if it had been given to me that way originally, I would have read it that way, but I didn't, so I don't want to change what I've already read.
Okay.
All right, 3905A. I think I already gave a version of that as well, right? Oh, maybe I didn't.
I'm not sure, Your Honor. You asked that we just include the case instruction rather than a special instruction. So this is just the case instruction.
Okay, so I will give that.
Your Honor, I also submitted a 3905.
Is that straight from the casing?
Straight from the KC.
Okay.
Are they
They're the same.
They're the same?
Correct. All right, 3934. That was not in the original package?
That was in the original package.
It was?
It was modified only because now that the damages are more limited than what Mr. Rosenjohn-Fossen was proposing earlier, we've just changed the last sentence.
Oh, okay. And I did not read that on Wednesday. Is that correct?
I don't believe you did.
Correct.
Okay, so I'll give 3934. Special instruction number 8.
Special instruction number 8, there are just two differences from the casing instruction. The first is that punitive damages cannot be awarded if there was accidental harm. The second is to include that's paragraph 3. Paragraph 4 is to include provocation as part of the jury's consideration of punitive damages. And we've identified a lot of supporting authorities in the notice that we filed with it. And I believe even Wittgen states that it's proper to instruct the jury on provocation when they're considering punitive damages.
Yes, Your Honor. My understanding was the trial would be bifurcated, and we would only get to this point after the jury made its decision as to the first non-punitive damages stage.
Well, this is a modification of the casing that is given during the first phase. So do you want to be heard on the modification, specifically accidental or heat of passion?
Again, Your Honor, I don't really see a need for this one because there is a specific casing on punitive damages that can be read.
I understand that. He is suggesting that it be appropriate to amend the casing to add accidental harm and heat of passion. Do you want to be heard on that?
Yes, Your Honor. So my point is that none of the cases should be changed. And this is an example of one that's really so far off and completely different than what the casing states. So that's my position.
All right, submitted?
Yes.
All right, I think special instruction number 8 is appropriate, so I'll give that. Special instruction number 9 is going to apply until we get to punitives. All right, let's go through plaintiff's proposed instructions.
There's one more I need to add 3932, life expectancy. I have it here.
It's printed out?
Yes.
And is the math right?
May not be. I'm willing to reduce it if that's the case, but I believe it's close to the number. Oftentimes, we'll have a stipulation with counsel, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So what evidence do you have that she will continue to have future? I guess she testified that it still bothers her, is that?
Yes, sir.
Okay. Any objection to 3932?
Yes, Your Honor, I'm not sure that she testified that it still bothers her, but in any event, first of all, this was never shown to me. We're not sure that the math is correct. And this is just not an appropriate, instruction in a case like this where it's over an alleged scratch and there's a overwhelming amount of evidence that it wasn't caused by it.
Can I respond to that?
Go ahead.
So I'm pretty confident that if it was changed to 40 years, it would fall well below the threshold of the National Violence Statistics Report. So I'm willing to do that. If there's a different number that they propose, I'm fine, but there should be some kind of KC 3932 of life expectancy so that the jury can understand that.
Where's that chart in the cases? Oh, here it is. And she's 32 today?
Yes, she's 32 years old. Yes, she is.
It appears to be correct. This is 50.3, they've got 50. All right, I'll give 3932 over plaintiff or defendant's objection.
Thank you.
All right, plaintiff proposed 3901. I think I already gave 3901. Is that not correct? No, I gave 3900. I did. Oh.
Your Honor, I
Yeah. So 3901 is only if liability has been established, not contested.
I apologize. That's an error.
Okay, so that's withdrawn?
Withdrawn.
Okay. 3902 already gave. 3903. I did not give, but I think that was proposed by the defense.
That's correct, Your Honor.
And that's, the defense version was straight from the casing?
Yes.
Well,
It's in the binder.
the one that I did, Your Honor, is from the KC, which seems to have a lot more words than theirs.
Yeah, I already did give 3903.
So we're gonna go with their version then?
It's straight from the casing. 3905, I think I already gave.
May I be heard on that, Your Honor?
Go ahead.
So the one that I've submitted today has all of the different types of physical pain, mental suffering, and emotional distress. Their version doesn't really cover everything at all. It just has a small amount. It's missing an entire paragraph, at least a portion of it. So I would request that plaintiff's version be read to the jury.
Right. I just looked. I did not give 3905 on Wednesday. And plaintiff's is straight from the casing.
Yes, sir.
And the defendant had a different one.
I think theirs is 3905A, so maybe that's why. But I would like 3905.
Your Honor, I believe the difference is that 3905 and 3905A, we just submitted them as separate instructions, and Plaintiff's counsel has combined them.
Your Honor, I don't think I've combined them, but
Oh, I see. The defense proposed version does not define.
doesn't cover.
Yeah, it's not the full instruction, so I'll give plaintiff's proposed instruction.
Thank you.
All right, 1600. I think I gave 1600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s, but I may be mistaken.
Your Honor, it was the 1602 instruction, which was the special instruction 4 we discussed earlier.
I did give 1600 already.
Then I withdraw the objection as to the 1600s.
Okay. Did we give a version of that?
1602 is the special instruction 4 that we discussed a few minutes ago.
And that, okay.
And
so I'll give the modified version.
Thank you.
1603, did we give that?
1603 was included in ours as well. I believe the court asked that we include it, so
Okay.
that's in our record.
And 1604,
I believe was given.
was already given. All right, tell me we have an agreed upon verdict form.
Unfortunately, we do not, Your Honor.
Can you highlight the differences?
Well, yes, Your Honor. So I've never seen it the way that they proposed it, with the preponderance of the evidence language. It's also something that was just created as a form that doesn't really reflect any type of special verdict that's really I've seen in any case before. I'm not sure what that is. So the one that I've done, Your Honor, I've done two different ones. The distinctions of the two that I've submitted is page 7 is added with respect to punitive damages. And the other version does not have the punitive damages. Question number 19. That is the only distinction between the two versions that I've filed with the court. I did give a courtesy copy to counsel. It was filed today at 12:19 a.m. with two different verdict forms. I did submit it to the court this morning without the caption of the attorneys, just so it would be somewhat of a neutral form. And I request that one of these be used because the one that they've provided doesn't really follow the usual method. I don't think it even has a signature line. Let's see. No, I withdraw that. But it doesn't really cover it the way that's usually done from what I've seen. Thank you.
All right, so I noticed the plaintiff's version has damages for each cause of action, which is duplicative multiple times over. It also doesn't include self-defense, and it also doesn't include what was the other affirmative defense?
Contributory negligence.
Oh, comparative.
Yeah.
Contrib went away a long time ago.
Yeah. Thanks.
All right.
I can modify it.
Your Honor, if I may.
Yes.
What we submitted was to simplify the form as much as possible. I believe it even has fewer questions than the plaintiff's form. And that was after our discussion that the previous form was complicated, which we agreed. We believe this is clear cut. It includes all the issues. It should not be difficult for the jury to understand or to answer.
May I respond here?
Go ahead.
So the worst part of it is it, again, states by a preponderance of the evidence. That's not usually in a special verdict form. It put that throughout the questions, kind of limiting, kind of creating a way for the jury to think ahead of time. It just doesn't make sense to have that there. I can modify mine. I have a printer. I can make changes in a couple of minutes. I print out the version that the court wants me to print. And the special verdict that I've submitted, I've seen all kinds of attorneys use it. I've never seen this version. And they would have to change it anyway because of the preponderance of the evidence, and it doesn't really tell the jury how to move along. So, for example, under assault, you have a question, yes or no, and then it says if you answer question 1 is yes, then answer question 2. If you answer no, then proceed to question 6. Theirs doesn't have any of that. It's very confusing and has that preponderance of the evidence language. So definitely I would ask that that language be taken out, preponderance of the evidence. And if it could follow more along the lines of a special verdict form, that would possibly make it a better form, but it's still a little confusing.
Your Honor, as far as the instructions, it's just clearly not true. The verdict form specifically states what the jury is supposed to do after they answer every question. There are other problems with plaintiff's form that would be beyond just little modifications. As you mentioned, the damages issue is very likely to lead to confusion and possibly duplicative damages awards. So if the court is inclined to ask that one of these be modified, we believe it should be this one. And we would, if the court has an issue with preponderance of evidence language, we could strike that language. Otherwise, it would be the same.
Can you strike it and print it within
Yes.
the next 5 minutes?
Certainly in the next 10 minutes.
Be heard?
Go ahead.
So again, Your Honor, the way that they've had it is not the way that the casing instructions read. The casing instructions do not have these boxes. It's a confusing way. It doesn't allow the jury to really answer the questions. They have to just say yes or no for everything. It doesn't break it down. So, for example, they're not able to answer the 4 parts of the question. For example, assault, it has 4 parts. And their form does not have the ability, the jury cannot answer the 4 different parts. They have to either go with everything or nothing. And that's not how a special verdict form, or any verdict form, is done. So I have a printer with me today. I can make changes. I can email it to the court if the court wants to do something with it. Their form doesn't cover any of these questions for any of them. Either it's all or nothing, and that's not how a special verdict form reads. So I would ask that the court. Well,
I'm just inclined to do a general verdict at this point in time.
I'm willing to accept that if that's what the court wishes to do, but theirs is really off base, and it does not cover all the 4 parts.
Your Honor, there's multiple causes of action. Affirmative defenses that apply to some causes of action but not others. We believe it's important, at least for our appeal rights, among other things, that we have a special verdict form in this case. I'd be happy to work on it.
Well, I mean, actually, I think the defendant's proposed verdict form is the equivalent of a general verdict.
Well, may I be heard, please?
Go ahead.
So again, I'm looking at my form here, and first of all, the question is, are we doing the punitive damages question? If I can narrow it down to, does the court want number 19 or not?
Well, I'm not inclined to do the plaintiff's version at this point in time.
No, I understand, but I just wanted to know if you wanted to have punitive damages, if that question, because the question is the same.
Your Honor, under the motion to bifurcate, the jury decides entitlement to punitive damages.
Exactly. So here's my question on punitive damages in the defense's proposed version. You've got punitive damages attached to negligence. Was that your intention?
Along with the instruction that it cannot be caused, that punitive damages are not awardable if the conduct was by mistake.
I'm sorry, you're saying you can get punitive damages for negligence?
No, not if it's by mistake.
Not if it's what?
No. We don't believe you can.
Okay, so but you do have a punitive damages question linked to question number 9, which is damages for negligence in comparative.
We can strike out the end of that, of 12.
Okay.
Question 12.
Here's what I want to do. I think the defense version of the verdict form is, for all intents and purposes, a general verdict on each cause of action. I think it's straightforward. I don't think it's confusing. And so the only remaining issue that I have with it is that you've got damages for each section, whereas there's a jury verdict that says that they only decide damages once. So how do we deal with that?
So we did it. We did the form this way just to avoid having to ask questions like, did you answer question this? Did you answer question that? However, if you look at question 7, for example, it says if you already answered question 4, which is the same, skip this question. So the intent is to have only one of those be answered. And if you fill the form out, that's how it works.
May I respond, Your Honor?
Go ahead.
Each cause of action can have its own separate damages. And that's why in their form it is the way that they have it, and that's why I did the same thing. So I would request that the jury be allowed to break it down on damages and decide what type of damages are for assault and battery. Those are kind of coupled together. It shouldn't be, but they are. And then intentional infliction of emotional distress.
And that arguably kind of makes sense to me. Let's say that they find that the assault was limited to the scratch and nothing more. That the scratch itself did not cause past or future, maybe isn't going to cause future emotional distress, but they find that the intentional infliction of emotional distress was more longer lasting.
For example, Your Honor, have you heard?
Go ahead.
For example, they may find that there was an assault and battery and no intentional infliction of emotional distress. By removing the damages section, they would never be able to award any damages. So that's why I request that it at least be left there so that they could give damages to the parts that they wish to give. And counsel on both sides can argue duplication, don't give it twice, break it down.
Your Honor, that would be incredibly complicated, difficult to separate. It wouldn't work. I understand your position, but there needs to be some way of ensuring that there's not duplicative damages awarded.
Your Honor, they have multiple attorneys on their end. They created this form. If the court is going to go along with their form, then they should have to live with the form that they created.
The form that we've created does not have that risk of duplicative damages. I'm sorry. The other thing is that I think we've already established with the jury instructions that there are not damages that are awardable under some causes of action but not others.
May I add one more thing, Your Honor?
Go ahead.
Yeah. I'm sure the court has seen it in many cases where it is broken down. There's the damages award specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction of emotional distress. In closing argument, counsel obviously can argue how this form should be filled out, and as confusing it is to me, I'll have to just live with it. To take away the damages section in assault and battery would mean that it is too confusing. It should be separate so that the jury can decide whether there should be any damages for assault and battery and any damages for any other cause of action.
Your Honor, we could, in theory, have one question for the damages and just not duplicate them. And that the only difference there would be we would have questions like, did you answer yes to question 3? Did you answer yes? Like what we did with the punitive damages. That would be one more difference.
How about we modify question 7? What are Ms. Ellis's damages? If you answer question 4, only include additional damages for this cause of action.
Can we include if any, Your Honor?
If any.
Okay, I'm confused. So again, it is very confusing because assault and battery is a separate cause of action and it has its own damages component. By leaving the form as is, the jury can then decide if they're going to give any damages for assault and battery.
They can. It's under question 4.
Right, in 4. And then they can do it again for 7. They can do it again for 9. They might not do it in any of them. So that way they're able to break it down and decide what, if any, damages they're going to be awarded. Each cause of action has its own damages award.
But you can't double count.
I'm sorry, Aaron?
You can't double count, though.
Double count? What does that mean, then?
Meaning include the same emotional distress that if they find that she has a certain amount of emotional distress, are you asking them to allocate it between the different causes of action or just...
No. I'm just straight asking assault and battery. This is what it is. If you find that an assault and battery, it should really be separate. Now, let's say we take it as together. We say, was there an assault and battery? And then what are the damages for assault and battery? It's really harmful to have it assault and battery combined because the swing that was taken was the assault and the cut to the face was the battery. So we're then limited to one damages in number 4. We're limited to one set of damages for both assault and battery. So then in my closing I have to explain that. Same thing, intentional infliction of emotional distress. Separate cause of action, it has its own damages. Negligence has its own damages.
Your Honor, I believe that, first of all, the addition that you proposed would address that. Not including something or just including more damages questions would make everything more complicated. Another proposal, Your Honor, however, is we could do separate verdict forms, one for and have damages only after liability. It would make things less complicated.
Go ahead.
So yeah, separate verdict form complicates it even further. This is a form that defense has prepared. It was well thought out, and it doesn't even break down the 4 different parts of the question. If we're going to live with this, I ask that at least we have those damages for each section. I'm not going to ask for the same thing 3 times. It's going to be, if I'm going to do it, I will break it down. This is worth this, the other is worth the other. It's not the same, Your Honor. So I ask that the form we submit it as is, and just if the court is going to go along with their form, then at least I would ask that. Thank you.
All right. I'm going to ask that you modify question number 7 to, if you answered question 4, only include additional damages under this cause of action, if any.
All right, that makes sense. Thank you. And what happens with the other one, Your Honor, number 9? Same thing?
Same thing. Can we do that?
Yes, Your Honor. Thank you.
All right.
And Your Honor, will we be giving number 13?
Yes.
Your Honor, just to confirm, question 12, we're going to omit the last 3 words or question 9.
Correct.
Thank you.
All right. There's a request for judicial notice regarding the date of the NBA game.
Yes, there is. I did file that yesterday, and I served it a copy on defense counsel.
And I'm sorry, what was the testimony of the date that the photograph was taken?
Miss Almánzar stated that that the photo was taken on the date of the NBA All-Star game, which was the date of the accident, the date of the incident of February 24, 2018, about 6:30 p.m. She testified that that's when the photograph was taken, and her nails looked like that on that date. There's no question that the All-Star game was on February 18th of 2018, so it's just a clarification so that the jury is clear of when the game is. This is common knowledge. There's no question about it. I've given different exhibits confirming that the All-Star game was on February 18th of 2018, and that's why I filed this.
All right. And for the defense?
Yes, Your Honor. What Mr. Rosen is saying is absolutely false. I'd like to read what my client testified to. Cardi, I'm going to put this in front of you. Cardi, can you please look at this photograph and tell me, do you recognize this? Answer, yes. Question, what's this photograph? Answer, that is me out here in LA at the All-Star Weekend NBA game. Question, does this picture refresh your recollection about what your hair color was that week? Answer, yes. What color was it? Answer, I'll say
Read
like...
more slowly, please.
Sure. Answer, I'll say like an ashy, dirty blonde. Question, can you see your nails in that photo? Answer, yes. Question, were you wearing acrylic nails or some other type? Answer, acrylic. Question, I think you testified yesterday that acrylic nails can last you up to 2 weeks. Is that right? Answer, yes. Question, are those the nails you had the entire time you were in LA? Answer, yes. And I can continue reading, Your Honor, but nowhere does my client say that this was taken on February 24, 2018. She doesn't reference a date. And Mr. Rosen represented this to you twice last Wednesday, that the court was advised and everybody was advised that it was on February 24th of 2018. He later said she testified that she got this picture taken on the same day. She testified under oath that at 6 p.m., he just said 6:30, on February 24th, 2018, that this picture was taken. That's absolutely false, Your Honor. I'd be happy to provide a copy of the transcript to the court.
Okay.
May I respond?
And one other thing, Your Honor,
Go ahead.
my understanding under California law is that you can't take judicial notice of the truth of the contents of a website. And there is case law on point I can refer the court to.
Well, I'm not necessarily worried about that. I'm just worried about whether... I don't think that there was any representations of the date it was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material.
May I respond?
Go ahead.
So, the purpose of this is really not to make anybody right or wrong. The purpose of the All-Star game took place, and the second half of it is when the photograph was taken. There's overwhelming evidence attached from different news outlets. There's
Again, is it material? The date? She said she had those nails for the entire week.
It's material, Your Honor, because the defendant testified that that's what she was wearing later in the day, exact same day. She had those nails. You have on the same date of the All-Star game and the same date of the incident. What was the error there is that the All-Star game was on February 18th of 2018, and the court said that we didn't have credible evidence at that time about it, so that's why the judicial notice was prepared so that the court can see for itself that the All-Star game was on February 18th of 2018. And
Okay, I'm going to deny the request for judicial notice. All right. Are we otherwise ready?
there's one more thing, Your Honor.
Go ahead.
The court asked that I prepare a statement regarding the death of John Sherritt.
Okay. You have that?
Yes, I do. I did give it to the court. It would say, plaintiff testified that she treated with John Sherritt, MD, in relation to this case in 2018. It is undisputed that Dr. Sherritt died on March 5th, 2021.
After a lot of back and forth, what we agreed to, what I agreed to, was that the court can instruct the jury that it is undisputed that Dr. Sherritt died, period. This March 5th, 2021 date, it's not in evidence. Plaintiff didn't testify. He said she understood he died sometime in 2021. She also testified, and we launched the transcripts. I can cite to where in the transcript she says it. Page 148, lines 12 through 149, line 15, she says that she went to see a Dr. Sherritt, and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Sherritt is not supported by the evidence. The only portion of this that is actually what I agreed to was it is undisputed that Dr. Sherritt died, period.
Okay. You heard? So, this is what I would propose reading. Plaintiff testified that she treated with John Sherritt, MD, does not dispute that Dr. Sherritt passed away.
Your Honor, she did not testify she treated with Dr. Sherritt. She sought medical treatment. This is page 148, line 12 through 14. Around that time, unclear when that is, did you also seek medical treatment from Dr. John Sherritt? I did. And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So,
okay.
That goes on page 149.
So I will read, plaintiff sought treatment with John Sherritt. It does not dispute that he's passed away.
Well, plaintiff testified. Plaintiff testified she sought.
Very good.
Thank you, Your Honor.
What will we read, Your Honor?
Plaintiff testified that she sought treatment with John Sherritt, MD. It does not dispute that he has passed away.
Thank you, Your Honor.
Oh. Now are you ready?
Well, there's a couple things. In my closing argument, I need the verdict form, so I can't start without
We're working on
that in hand. The other thing I wanted to say, Your Honor, is Your Honor did allow me to argue and clarify the NBA All-Star game when it was, the photograph. I want to be very clear that I intend to argue that in my closing.
That's not in evidence. I think what you said was they didn't provide the date. And you're fine. You can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing.
You could argue it. You could argue that they didn't establish what the date was.
And also that the All-Star game was on February 18, 2018, the week before. But the week before the incident, I don't see the harm in that. they can object to that. They can say their version. But that's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. He's never produced this
Okay.
discovery.
Go ahead.
Just briefly, a couple of questions. First, if you remember, counsel violated a motion in limine order. And now he's talking about arguing things that are not evidence, which is completely improper. I don't want to object every 5 minutes to his closing argument. I would ask that at least let me say, if the court doesn't want to tell him, that he has to follow the rules. He can't argue out things that aren't in evidence. He can't violate the motions in limine.
I think it's readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. If he wants to present that and you want to object, then that's how we'll proceed.
Thank you, Your Honor.
Are you the same? Are you done?
Then two procedural questions. Does the second monitor work and can it be facing the jury so they can clearly see it?
I don't think so. We're in the middle of a transition and I don't know.
Okay. And
We can see it's not.
Your Honor's preference, we have demonstratives and we have things we're going to show, intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right. Anything else from plaintiff's counsel?
Yes, Your Honor. I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence.
I think you just said you were going to.
No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the day.
Correct. Your position on Wednesday was that they didn't establish the right date, and you can make that argument.
That's exactly what I wanted to do.
Okay.
Thank you very much, Your Honor.
All right. Are we ready to move in the jury?
I must have the verdict form before I start.
All right.
They're being printed right now.
Okay. All right. Let's move in. All right, welcome back, everyone. We're still on the record in the Ellis matter. We now have defendant with us as well as the members of our jury and our alternate. Based on the fact that you're all here, I'm assuming no one hit the lotto over the weekend. Folks, we thank you for your patience. We did have a few procedural issues that we needed to address prior to bringing you in. We are now ready to proceed with the last batch of jury instructions. I'll try to give context to these to the extent that it's necessary. I will put them into the package where they belong, but I do need to give these to you. And we're going to relieve the court reporter of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almánzar assaulted or battered Ms. Ellis, you should fine for Ms. Almánzar if you decide that Ms. Almánzar was acting in self-defense. To succeed, Ms. Almánzar must prove both of the following by a preponderance of evidence: that Ms. Almánzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almánzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almánzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almánzar must prove both of the following: that Ms. Ellis was negligent and that Ms. Ellis's negligence was a substantial factor in causing Ms. Ellis's harm. If Ms. Almánzar proves the above, Ms. Ellis's damages are reduced by your determination of the percentage of Ms. Ellis's responsibility. I will calculate the actual reduction. Ms. Ellis may only establish her claim for negligence if she proves that Ms. Almánzar engaged in negligent conduct that caused Ms. Ellis to suffer physical injuries. If Ms. Ellis can prove that Ms. Almánzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Ms. Ellis cannot establish her claim for negligence. Emotional distress in suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Ms. Ellis claims that Ms. Almánzar assaulted her. To establish this claim, Ms. Ellis must prove all of the following: that Ms. Almánzar acted with the intent to cause harmful or offensive contact, that Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner, that Ms. Ellis did not consent to the conduct, that Ms. Ellis was harmed, and that Ms. Almánzar's conduct was a substantial factor in causing Ms. Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds of decency. Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether defendant abused a position of authority or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was particularly vulnerable to emotional distress, and whether Ms. Almánzar knew that her conduct would likely result in harm due to mental distress. Under Factor A, which is the position of authority, examples of positions of authority or relationships of power include an employer, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almánzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almánzar knew that emotional distress would probably result from her conduct, or Ms. Almánzar gave little or no thought to the probable effects of her conduct. If you decide that Emani Ellis suffered damages that will continue for the rest of her life, you must determine how long she will probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another person is likely to live, but is not conclusive, since health, habits, activities, lifestyle, and occupation. Ms. Ellis seeks damages from Ms. Almánzar under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether Ms. Almánzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by Emani Ellis: physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional distress, Emani Ellis must prove that they are reasonably certain to suffer that harm. For future physical pain, we're fine. For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate Emani Ellis for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almánzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almánzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almánzar engaged in that conduct with malice, oppression, or fraud. If you define that defendant accidentally harmed plaintiff, punitive damages are not appropriate and should not be awarded. In deciding whether or not to award punitive damages against the defendant, you may consider whether defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with the intent to cause injury, or that a defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences. Oppression means that a defendant's conduct was despicable and subjected the plaintiff to cruel and unjust hardship in knowing disregard of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed a material fact and did so intending to harm the plaintiff. During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away. All right, ladies and gentlemen, that concludes the additional jury instruction, and we're back on the record with the court reporter. That concludes the additional jury instructions that we are adding to those instructions that I previously read. At this point in time, it is the time for the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who are to determine the facts, and to the extent that the attorneys argue facts that you do not believe were proven during the trial, please rely on your own finding of what the facts are. And similarly, to the extent that the attorneys argue law that is contrary to the law that I've just given you, please rely on the law that I gave you. And with that, is plaintiff prepared to give your closing argument?
Yes, Your Honor. I would just ask for a quick sidebar for a moment, please.
All right, we had a brief conversation at Sidebar, and now is plaintiff prepared to proceed with your closing argument as soon as you get there?
Yes, Your Honor. Thank you very much.
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
Thank you all for coming back today. So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe
a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar, or the cut, came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails. And that there were 3 different scrapes, 3 different scratches. And that the middle one was the deepest one. And that's really the one that he worked on. Now, the issue in this case, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss also known as Cardi B is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay? If you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard, and she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are, Emani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Emani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. Instead, the defendant thought that, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person. And she simply, her whole goal of doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard. Be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is, recording video is not available while on a call. So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almánzar, Cardi B, got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N-word to disrespect her, calling her the B-word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher a sentence that basically that there's this undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
Then we learned throughout the case that when Cardi B came to the building, she caused a disturbance. She caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming, to the point where 2 other witnesses Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke. It was so loud that those two people came out after about 40 to 50 seconds. Now, the issue with that is those two witnesses didn't see the four things that happened before that, which happened in the 40 to 50 seconds before. So yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those two witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those four things happening? Being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry, she was emotional. So when these two witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that, and they had assumed that it's her fault, maybe, or that she did something wrong. But again, those two witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the two people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? It could be from either one. It could be from the commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything. At some point during the trial, the defendant showed you Exhibit 232. You all remember this photograph? Exhibit 232. This is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection.
There is no proof of when this photograph was taken. It could have been taken at any time,
Objection.
before or after the incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor.
That was her testimony. But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere? That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on this photograph because there's no date on this photograph. next thing that Miss Ellis did is she made an incident report. 2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, at least downstairs of the building. She had a security guard with her, Mr. Newton. Mr. Newton, that's her security guard. He didn't testify in this case. Why not? Where is he? Disappeared? Miss Ellis testified that when she saw this security guard downstairs in the lobby, and she met with him there, Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified in this case, but he didn't. And there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So, where is Mr. Newton? I don't know. He was on the witness list. He should have came here and testified.
Assisting.
Another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case. And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw the Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple reasons. One is, you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. If the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. The medical treatment was delayed. That's why Ms. Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lien basis. Dr. Mulliken testified that he would agree to that he treated her on a lien basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did. Dr. Mulliken testified that he fully examined Ms. Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Ms. Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Ms. Ellis could... there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also, as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind. It does remind. Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor from the defense side. They could have spent money and hired somebody and had them testify here and tell us, yeah, Dr. Mulliken's work is no good, or she could have done something different, but we don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. And he's a board-certified plastic surgeon for 30 years. He's affiliated with UCLA, and even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves. Now, when you go back into the jury room, you will see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding.
Objection, Your Honor.
They were raised.
Sustained.
When Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was the security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen. And that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony. When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. Cardi B refused to listen to the security guard who was working there. At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor.
Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022. Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down.
Let's stick to what the evidence shows.
Yes, sir. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022, and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser she didn't tell him about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home, that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case to, in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything had already been done. The whole incident already happened. The injury was already complete. And really, this comes down to believing Miss Ellis. She gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure, and yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B, and Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again. Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Ms. Ellis also received another 12 visits. She testified that she saw psychologist Dr. Avila and other
Objection, Your Honor.
people in his office.
Violation of the court's order.
Move on. The other thing that Cardi B failed to do, or could have done, is she could have filed a cross-complaint.
Objection, Your Honor.
All right. And then I want to go over a little bit about the medical bills. So you don't have to get it exact. It doesn't have to be an exact number. But there was testimony in this case that Ms. Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Ms. Ellis could benefit from one more surgical procedure, another one, to make it better. The cost of that was $15,000.
Objection, Your Honor.
Overruled.
The $15,000 that would be paid for that would, in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce, basically what I'm saying is there's still some scar on her face. And if you want to look at it, you're more than welcome. You can have her walk around, you can look at it for yourself. There is still some scar on her face. It's still there, and still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happened to Miss Ellis are they're wrong. And we want to make this wrong right. And how can we do that? Through each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now, for today's purposes, is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, component of that is pain and suffering. There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering, you are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do. So, when you go into the jury room, you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case. The first section A is the assault and battery. They are, in a sense, separate because the assault is the swing and the battery is the scratch and the cut to her face. However, it's very clear. Did Plaintiff Emani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis, Marlenis, Almánzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almánzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side, it's not broken down into 4 parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay? And then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almánzar's conduct. Miss Ellis was harmed, and Miss Almánzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2, both of those. Then you have question number 3. Did Miss Almánzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almánzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almánzar herself, her position was, I didn't touch anybody, and nobody touched me. So self-defense, no. You would say no. Then you can go. Then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Miss Ellis incurred in this incident. So you will have in the jury room exhibit number 4. You'll have exhibit number 4. It's been marked at the bottom right corner. You'll have exhibit 4-1 through exhibit 4-6, and then it will skip over and you will go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500. So past medical expenses would be $16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulliken stated that Miss Ellis would benefit from a future plastic surgery of $15,000. So you'd write $15,000 in that box. Pain and suffering. Again, there's past pain and suffering and future pain and suffering. The court read a time frame for you of how many more years Miss Ellis will live. And the jury instruction life expectancy, 3932, basically states that Miss Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she's going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period. And again, you'll all have the jury instructions in the back when you go into the jury room. And the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important. So I would take a look at that one, because it covers all of the different things. Embarrassment, pain and suffering, disfigurement, all of those. So if you look at 3905, it talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that. So for past non-economic loss, you should put a number there. Because if you don't, the award will be thrown out. You got to have at least $1 there. You got to award some kind of pain and suffering. It's required. Now the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury. Very serious. And Miss Ellis has been suffering for the last 7.5 years. What kind of weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to. So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic. We all went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized what life is really about. Future non-economic loss. Again, that's going to be for the 50 years going forward. You could pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number 1, Miss Almánzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. Miss Almánzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almánzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, Again, it says, did Ms. Almánzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is, if you feel there should be separate damages aside from the assault and battery for the emotional distress, then this is where you can give that amount of money. It'll be a separate and apart damage area for you to award more damages. The same breakdown. You can give past medical expenses, obviously past and future medical expenses. In this, if you awarded in the first box, then you would say 0 and 0, because we're not asked double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give $50,000 additional for the past, $50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury room. And I'll close with this. Did Miss Ellis prove all of the following elements of negligence? Miss Almánzar was negligent. Miss Almánzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almánzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almánzar, was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almánzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then, again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through. The assault, the battery, the emotional distress, all that she should be compensated for. And then there's a box, did Miss Almánzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almánzar? Say 100%. And Miss Ellis, 0. And the final page deals with punitive damages. Did you answer question 4 or 7? And you look back, and if you did, which is the damages, then you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almánzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Ms. Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here. So at this point, I'm going to turn it over to my counterpart. They will obviously contradict everything I will say, I've told you, and then I will have a chance to come back and rebuttal and clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and I work with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I had. And we really, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And we want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Emani Ellis went through, and I'm asking you to award Miss Ellis an amount of money that you think is fair that will make her whole for the losses that she suffered in this case. Thank you very much.
All right. Thank you, counsel. You okay? You want to take a break? You okay? Okay. All right. Is the defense ready to proceed?
We are, but I would think a break would be appropriate at this point.
Does anyone want a break? We got started late. Okay. Why don't we take a short break? Why don't we resume back at 11:25? In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 11:25. The modifier we, it's probably, I wasn't going to get into it. It's generally not proper to include yourself in terms of what we all went through, but that's why I was overruling the objections. One note, and is this grandmother here?
Yes.
Ma'am, can I have you step forward? Can I have you step forward? And ma'am, you were previously sworn, and you understand you're still under oath?
Sure.
Did you have any conversations with alternate number 1 on Wednesday?
Alternate number 1?
The woman on the corner? The woman who's on the jury?
No.
You don't recall any interaction with her?
She sat next to me and she was waiting on a break, but we didn't speak.
You didn't speak with her? Okay. So you didn't talk to her about the trial at all?
Absolutely not.
Okay. All right. You were just seeing, we thought that there may have been some discussion between the two of you. You don't recall that?
Mm-hmm.
Okay. All right. Thank you. All right. Something else?
Yes, Your Honor. Although you cautioned counsel that he can't argue things that are not on the evidence, he repeatedly did. He even started talking about Dr. Avila's treatment, even though he was excluded. Over and over and over again. And all the jury sees is me objecting and Your Honor sustaining it. I would request that you admonish the jury to disregard all of the statements that you sustained objections to. I would also ask that you assign misconduct to counsel and that he be reprimanded, because this has just been ongoing.
Okay. We can discuss.
I want to respond.
Well, let me do this. I will give further instruction to the jury about that the argument of counsel is not evidence and that they should disregard any comments that were not supported by the evidence, I will give that instruction. We can discuss whether or not we want to set an OSC after the trial for any alleged conduct.
Thank you.
Your Honor, may I please say one thing?
Yeah.
Please.
Go ahead.
I just want to note that you advised Mr. Rosen that if he were to argue to the jury that Cardi said that photograph was taken on February 24th, that would be a knowing violation of the professional rules, and that's exactly what he did.
Okay.
Yeah,
Well,
I wanna respond.
why don't we? I don't want to do it now.
Well, I have to say something about it.
You don't. I said we'll discuss whether or not we want to set an OSC and we can address it then. Okay.
Thank you, Your Honor.
All right.
So, Your Honor, when you left the courtroom, Mr. Peterson made some remarks to me that were rude.
Why don't we do this later? I'm not going to have the jury wait for
I
this.
ignored him. I didn't talk to him.
Okay. All right, we're going to bring in the jury.
It's complete falsehood.
It's Mr. Anderson, too.
All right, welcome back, everyone. We're back in the record in the Ellis matter. Counsel and the parties are present, as are the members of our jury and our alternate. And before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections. To the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial, please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial. Okay? All right, with that, defense can give their closing.
Thank you. Good morning, everyone. Good morning. I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and it was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statement, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show, and that I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in. The witnesses have testified. The exhibits have been admitted. And if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I'd ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated by this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%. She starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has. That arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they caused someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation? Who caused the incident? And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way, I'm going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, and then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true. Okay? She has her version, but the fact that she alone says it does not actually make it true. And later this morning, maybe stretch into afternoon, I'll tell you, or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. But plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor. Misstating testimony.
And she actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on this scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-bill cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's Exhibit 200. She gets calls, and she makes calls from 11:20 a.m. all the way to 3:35 p.m., and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021 she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021, is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulliken. She went to plastic surgery 4 years later after being in a car accident.
Objection, that misstates the testimony.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today, that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower. I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Actually, you're not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives, and we hope our parents believe us, and our grandparents. But parents But remember what Judge Fusselman said at the very beginning, common sense. Okay? We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything. And they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi, half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say, guess what, Mom, guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out. Because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay? Well, that sure doesn't square with the testimony of Tierra, Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek? But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Emani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday. Question, you didn't call your grandmother though, did you? Answer, no. Okay? So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses, is Dr. Mulliken. Okay, that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show a scar. That is you'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay? That's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show the. Okay, then we'll show. This was played for the jury before. It's Cardi's testimony. Excuse me, plaintiff's testimony as to how she was supposedly cut by Cardi.
When you say like this, she put her finger.
Pointing, yes, so like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulliken's testimony that it was a right-handed person who scraped with an index finger and 2 other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claim scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulliken says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with a straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulliken says that in his professional opinion, and counsel talked about how well-respected he is, that it was a right-handed person who scraped 3 fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulliken to testify that a left-handed person might have made the claim scar. But that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulliken testified that he can't say when plaintiff got the claim scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulliken. And Dr. Mulliken also testified that he can't say whether the claim scar was caused by an intervening accident or some other cause.
Objection on the state's testimony.
Ladies and gentlemen, you heard the evidence please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And, Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulligan's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session, in his mind, is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing. Even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulligan testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or microneedling. Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulligan also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulligan, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulligan also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulligan. Dr. Mulligan knows that he is going to get paid, if at all, his $17,500, only if his testimony helps plaintiff recover money in this case. That is a big incentive, and because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018 she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned, she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that She got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified...
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
I can stop there if you want.
Okay. All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30. On this matter, counsel, the parties are present, as are the members of our jury and alternates. We're going to resume the defense closing argument.
Thank you, Your Honor. Good afternoon. We're back. So picking up where I left off, Cardi testified in this courtroom that the whole encounter was maybe 45 seconds, less than a minute. Counsel has urged, and I'll get back to this as well, that she didn't see what happened before, but if you add her and compare her estimates with those of Tiara and Dr. Finke, who said that it lasted about 45 seconds, it's clear that they came out right at the beginning. Now, Cardi also testified in front of you and under oath that she never spit on plaintiff. She never struck or cut plaintiff. She never touched plaintiff's face. She never used the N-word. She never threatened to get plaintiff fired. Cardi also testified that she is, in fact, left-handed, and we've talked already about how that undercuts Dr. Lanikin's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles. She lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star Week. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the alleged incident, on February 24th. That's absolutely untrue. She did not testify to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not, in fact, testify to is something that Your Honor that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently coffin square means the shape and the square, and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy, and they had no sharp edges. Apparently you can get little rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke, a fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which, of course, flat can't cut anything. And she testified, as did Dr. Finke, I misspoke. She testified that they were flat. Dr. Finke, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have 2 witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that his client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault, and if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense. or that she cut plaintiff. The point he's overlooking is that is up to you. We've heard the evidence. We think it's overwhelming that Cardi did not touch plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a self-defense, a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both Cardi's testimony, Tiara's testimony, Tiara Malcolm, and I believe also Dr. Finke. But let's talk about Ms. Malcolm. Tiara Malcolm, we called her as a witness, so we'll add her there. And she is one of the 4 people who are in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. Defense counsel has argued that, again, that she wasn't there in the beginning, but we know from her testimony that she was near the door, immediately ran out when she heard yelling. Now, we have a visual rendering based on plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them, with Cardi behind her and with Ms. Malcolm facing plaintiff. The evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with plaintiff. Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified, what Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not realize, with Cardi behind her and plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head. Counsel has argued
Your
that...
Honor, I would object to him referring to counsel. We can talk about facts on counsel.
Plaintiff's counsel has argued to you that the that Ms. Malcolm didn't know who hit her. Okay, and he dwelled on that a lot in his cross-examination of Ms. Malcolm, and with all the things flying, with all of the plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head, but she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threatened in no uncertain terms to harm Cardi. Quote, "I will F your shit up." That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face-to-face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that since she testified here that she was using earphones. We've got another witness who says plaintiff was standing there, flailing away with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked, what about chest to chest? And Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt that plaintiff was at fault and, quote, she handled everything unprofessionally, close quote. Now, we also called Dr. Finke. He, too, was there the day of the incident, and he, too, has no axe to grind. He is not her regular doctor and never has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NBA All-Star Weekend and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tiara Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling, and he immediately ran to the front. Okay, so he gets there very quickly, too. And he just has a little bit more distance to cover. And he testified, like Cardi and like Ms. Malcolm, that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway, and that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out, and also that Dr. Finke, once he got plaintiff to leave, which he refused to do, that he went back into the office, so he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood in her face from a scratch that has supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there when plaintiff expressly threatened harm to Cardi by saying, I will F your S up. Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting term, that was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his administrator, his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Ally, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe the evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. Plaintiff, who testified, if you remember, that incident reports are very important. And she testified And in the incident report, she told her supervisor that that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's, with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Allied and the building owner, quote, for behaving the way I did. Okay? Why would she apologize to them if she was attacked? Why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam.
So you can wrap up in about 10 minutes?
Can I have a little bit of extra time since counsel got extra time?
I don't know that you did, but please try to wrap up.
Okay. I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie. Nicole McKenzie is an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie in April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKenna testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when Dr. McKenzie did the evaluation, plaintiff made no mention of being scratched, cut, or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching. Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her. Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. And in response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that were reported, and also that if she saw the patient and saw, if they've got a cut or a scrape or a bruise or whatever, she'd note that as well in the report. And none of that was noted because none of it existed. We also asked plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes in psychiatry. He has impeccable credentials and decades of experience. He, by the way, does not work on a lien basis. He does not work, we paid him, he does not work on a lien basis, so he doesn't have the same incentive that Dr. Mulliken has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in his report, he specifically said no diagnosis. But he did come to conclusions, okay, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms, different symptoms, and so many symptoms that only 2 out of 1 billion people in the world have those symptoms. He also testified that there were inconsistencies with her story. We talked about the McKenzie analysis, in fact, that the plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We've talked about the initial incident report, which says a scratch on the nose, but not a scratch on the... So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape. But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff went into Kaiser for a complete history and physical, and plaintiff specifically, in questioning, denied any kind of mental health issues, including anxiety or sleep problems. In April 2023, she went in again, and for hand pain that time, and she was specifically asked, Dr. Rosenberg said that's what Kaiser does. They ask you about everything, just noted in the records. And she was asked, but again, reported no emotional problems and did not request mental health assistance. I should also mention this claim about PTSD. Dr. Rosenberg testified that you can't, quote unquote, an argument or an unpleasant interpersonal interaction isn't a trauma and can't lead to PTSD. The claim of PTSD is frankly an offense to those people who actually have it. She had a 45-second argument. She was fired. That is not what gives you post-traumatic stress syndrome, and we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulliken is a plastic surgeon. He's not a psychiatrist. So Dr. Mulliken couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories. First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it. And everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified in her February 26, 2018 incident report. Plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was a terrible spitting at the client. Now it's, well, maybe it was an accidental spittle, say it, don't spray it kind of thing from junior high school. There's no evidence that that happened, but it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault, and there's no evidence that it even happened. Plaintiff also is strikingly inconsistent regarding her claim that Cardi touched her. We'll go through this quickly. We talked about in the February 26, 2018 incident report, supposedly Cardi scratched plaintiff's nose. In April of 2018, plaintiff told Dr. McKenzie that Cardi almost touched her. In sworn responses in discovery in this case, plaintiff stated under oath that Cardi viciously beat plaintiff about the head, face, and body. You haven't heard that, in this trial. No one said that occurred. In her deposition, plaintiff stated under oath that Cardi struck her on her nose and cheek, and plaintiff acted out Cardi jabbing plaintiff's face with an outstretched index finger, which is directly contrary to, and you saw that videotape of that, it's directly contrary to what Dr. Mulligan testified he thought happened.
Objection, Your Honor. We're going about over an hour now.
What's your objection?
That we agreed to 1 hour.
Okay, counsel, why don't you wrap it up?
Can I have 3 minutes?
Just wrap it up.
Okay. I'm sorry, there's more to talk about, but I've got to go. Ultimately, this case comes down to what happened in a minute in a medical building hallway. And to believe plaintiff, you would have to disbelieve Cardi, you would have to disbelieve Ms. Malcolm, you would have to disbelieve Dr. Finke, and you would have to ignore all of plaintiff's contradictory statements, including whether she had a cell phone, whether she had an earpiece, all that stuff. This is not a difficult case. It is not a close case. Plaintiff has the burden of proof, and the evidence is overwhelming in Cardi's favor. Plaintiff has not met her burden of proof. And plaintiff's demand for whether it's the $24 million that was testified to at trial or the $250,000 plus that you heard today makes no sense. She suffered no injury. Cardi did not do anything wrong except try to protect her baby and get to a doctor. The court will provide you with a verdict form, and we urge you that the evidence and common sense require that you answer questions 1 to 2 as no. That will skip you over to Section B. We ask that you answer question 5, no. That will skip you over to Section C. We ask that you answer question 8, no, which will skip you to Section D. We ask that you answer question 12, no, which is then the end of the verdict, and you can have the foreperson sign it. I also want to note that for each of these questions, as the judge previously told you, 9 people do not have to agree. You can have 9 people agree on one, a different group of 9 people on another. And we ultimately, we thank you for your time, for your consideration, and you know how we wish you rolled. So, thank you.
All right, and folks, as we indicated, plaintiff gets the first and last word, so time for a rebuttal case for plaintiff.
Yes, thank you, Your Honor.
Good afternoon. Thank you all for coming back. So this is the end of the road now. I said a lot of things this morning, and I basically don't want to repeat all of it. The main point that I want to highlight, which what counsel has brought up, is the incident report. In the incident report, Ms. Emani Ellis tells her supervisor that the defendant put her fingernail into her face. You will see that. Into her face and scratched her nose. She caused damage to her face. It was a physical contact. As far as the spitting, I never brought up the word spittle. I don't know what that exactly means, but in either event, Emani Ellis, who was there, who was a witness to this incident, testified that the defendant spit on her, actually spit on her, which is an assault and a battery. everybody gets an attorney. Everyone gets to have an attorney. Even Cardi B gets to have an attorney. All of these comments and all of these things are smoke and mirrors to hide up the truth. Bottom line is, Miss Emani Ellis, who was there, testified multiple times. She never did anything wrong in her life. She was a model citizen, good person, and she basically was doing her job as a security guard, and the defendant refused to cooperate, caused a disturbance, physically assaulted and battered her, spit on her, took a swing at her, and ultimately a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire incident really took place between Emani Ellis and Cardi B, and it really is going to come down to who do you believe? Who do you believe? Are you going to believe Emani Ellis, who was a security guard, who did her job, who was there, who never had any problems of any kind? Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your Honor.
Got angry on that day. There's no question. She admitted it. She said she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word, disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish and try to get a reaction out of her. I don't know how it was that Emani Ellis was able to contain herself. Maybe because she is so peaceful. You heard lots and lots of testimony about how she was peaceful. The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this scratch, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you. He said it could be done by either a right-handed person or a left-handed person, either one. And when we had Cardi B on the stand, she said she was disabled because she was pregnant, but at the end of the day, she wasn't disabled with her hands, and you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a bat, in baseball you must use the correct, no. This injury could happen with the right hand or left hand, and Dr. Mulliken clarified that and said it could happen with either hand. Again, the evidence that needs to be brought forth needs to be proven by a preponderance of the evidence. We don't have to prove 100%. We have to prove a featherweight more than 50%. In this case, we have given you so much different evidence from different people, which was Emani Ellis, her grandmother, her mother, and all of the medical records. We have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Emani Ellis should receive to make her whole. And counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Emani Ellis was assaulted and battered, and we thank you for your service.
All right, thank you, counsel. All right, ladies and gentlemen, that concludes the presentation of evidence and argument. You're now going to be shown to the jury room. We do have a hard stop at 4:30, and by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow. If you want to take a break, you can take a break, but you all need to be back together in the jury room, so please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But for now, can I have Cynthia swear in Vanessa, please?
Yes, Your Honor. The alternate, are we going to go to the jury?
Yeah.
Please raise your right hand. Do you you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself, nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court, and when they have agreed upon a verdict, you will return them into the court, so help you God?
I do.
And do you solemnly swear that you will take charge of the alternate juror and keep her apart from the jury while they deliberate on the cause until otherwise instructed by the court, so help you God?
I do.
May I please have you state your first and last name for the record?
Vanessa Garcia?
Thank you.
Vanessa?
Yes, ma'am.
I want to talk to the alternate before she goes.
Grab your pens, notebooks, and personal items, and we're going to go ahead and head into that jury room. Juror number 8 is going to be lady. Juror number 7, if you want to come up, please. And alternate, if you could just stay in your seat. Thank you.
Counsel, do you see that the door's closed? There it is. Okay. All right, we're still on the record outside the presence of the jury. We do have the alternate number 1 here. Ma'am, on Wednesday, did you have any conversations with any of the witnesses? Were you sitting? Yeah, you.
Me?
Yes. Were you outside? Did you sit next to the plaintiff's grandmother on Wednesday?
The grandmother?
Correct.
I can't remember, but I did sit once, at least once.
Did you have a conversation with her?
I don't remember what I said, if I did.
Okay, so she didn't say anything.
I didn't say anything about this.
Nothing about the trial?
No.
Okay, very good.
Not at all.
Vanessa's going to excuse you to the jury room. All right. Thank you, ma'am.
Okay. I'll take your notebook.
Thank you.
And then I'll take your...
Thank you.
And just for the party's information, they had some kind of conversation. It may have been innocent. I just wanted to rule out an improper contact.
Thank you.
If you could please either stay close or give a cell phone number to Cynthia. Just please stay within a couple minutes in case we get any questions from the jury or if we get a verdict.
Your Honor.
Yes.
So I do want to put something on the record, but not about counsel.
Okay.
I think it's important. I think this court has a duty to handle the situation, which is what happened. During the lunch hour, Cardi B went outside and threw something at one of the news reporters. I have it on video. She's been staring at my clients, all 3 of them, trying to intimidate them. I think it's unfair, and it's they feel scared. They feel scared about what she may do to them because of what she did to that court reporter, which I have on video.
To the court reporter?
I'm sorry, to one of the news reporters. She threw an item at the news reporter physically in front of this courthouse on court property outside this courtroom. So I would ask that she be admonished and be told not to handle herself in this way and not to look at my clients anymore.
All right. So the court can't make any orders for conduct that the court didn't witness.
I can show the court the video.
Well, I still haven't witnessed it. To the extent I think it appropriate that the parties be courteous to each other. I don't think it's appropriate for anyone to be either threatening anyone or even by way of staring at someone. People can take offense to that. So please continue that courteously with each other.
May I just add one thing?
Sure.
I've been sitting here throughout the whole trial. Plaintiff has never looked this way, so I don't know what she's talking about.
Okay.
Second, Plaintiff is halfway between Cardi and the jury box and the witness. I have never seen Cardi do anything else other than watch. Sometimes he, in response to a witness, may wonder what. But I have not seen anything that plaintiff's counsel has claimed.
Okay. All right. And we do have extra security here just in case there's any kind of issue. All right. All right. Stay close. Rough.
Yes, sir. Thank you. Over and over and over again, and all the jury sees is me objecting.
That were rude.
We're going to bring in the jury. Back in the record.
Presence of the jury. Question for counsel, just in the interest of saving the time to read the verdict, can the clerk only read the call to the question? For example, for number 1, did plaintiff Emani Ellis prove all the following elements of battery, and then yes or no, rather than reading the entirety?
That's fine with us, Your Honor.
I would like the entirety, I'm sorry.
Any particular reason? It's not going to change the answer.
Well, I feel like the verdict form was not
Okay.
the very type of form.
Okay. We're now joined by the members of our jury and alternate. And who is the foreperson? Do we have a foreperson? Number 3? And have you reached a verdict?
Yes.
Can you hand the verdict to the clerk, please? All right, can the clerk please read the verdict?
Superior Court of the State of California for the County of Los Angeles, Emani Ellis, plaintiff, versus Belcalis, Almánzar, Cardi B, does 1 through 50, inclusive defendant. Case number 20 STCV 07031. Verdict. We, the jury, in the above entitled case, answer the questions submitted to us as follows. Section A, assault and battery. Question 1, did plaintiff Emani Ellis prove all of the following elements of battery? 1, defendant Belcalis Almánzar, Ms. Almánzar, touched Ms. Ellis in the intent to harm or offend Ms. Ellis. Number 2, Ms. Ellis did not consent to being touched. Number 3, Ms. Ellis was harmed or offended by Ms. Almánzar's conduct. And 4, a reasonable person in Ms. Ellis' situation would have been offended by the touching. Answer, no. Question 2, did Ms. Ellis prove all of the following elements of assault? Number 1, Ms. Almánzar acted with the intent to cause harmful or offensive contact with Ms. Ellis. Number 2, Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Number 3, Ms. Ellis did not consent to Ms. Almánzar's conduct. Number 4, Ms. Ellis was harmed. And number 5, Ms. Almánzar's conduct was a substantial factor in causing Ms. Ellis's harm. Answer, no. Section B, intentional infliction of emotional distress. Question 5, did Ms. Ellis prove all of the following elements of intentional infliction of emotional distress? 1, Ms. Almánzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. 2, Ms. Almánzar intended to cause Ms. Ellis emotional distress. Number 3, Ms. Ellis suffered severe emotional distress. And number 4, Ms. Almánzar's extreme and outrageous conduct was a substantial factor in causing Ms. Ellis to suffer severe emotional distress. Answer, no. Section C, negligence and contributory negligence. Number 8, did Ms. Ellis prove all of the following elements of negligence? Number 1, Ms. Almánzar was negligent. Number 2, Ms. Almánzar's negligence caused Ms. Ellis to suffer physical harm rather than only emotional distress. And 3, Ms. Almánzar's negligence was a substantial factor in causing Ms. Ellis's harm. Answer, no. Section D, punitive damages. Question 12, did you answer question 4 and 7? Answer, no. Signed this date, September 2nd, 2025, by foreperson George Uloa, number 3.
All right, does anyone wish to pull the jury?
No, Your Honor. Yes, Your Honor.
All right, let me ask the foreman, was it unanimous as to all the questions?
Yes.
All right, so the question that the clerk is going to be asking is, was it unanimous as to all questions?
Question 1.
Or just all questions?
No, as to all questions?
Was it
Yes.
unanimous?
Was it unanimous?
Yes.
And we go through each of the jurors. Was it unanimous?
Was it unanimous, juror number 1?
Yes.
Number 2?
Yes.
Number 3?
Yes.
Number 4?
Yes.
Number 5?
Yes.
Number 6?
Yes.
Number 7?
Yes.
Number 8?
Yes.
Number 9?
Yes.
Number 10?
Yes.
11?
Yes.
And 12.
Yes.
All right, sounds like it was a unanimous verdict as to all questions. Can the clerk please record the verdict?
The verdict has been recorded, Your Honor.
All right, thank you. Ladies and gentlemen, thank you for your time and dedication to this case. I know that you've paid a great deal of attention throughout the matter, which was especially evidenced by the questions that you did submit. I want to thank you for that time and attention on behalf of myself, the parties, the court system, as well as the people of California. As I indicated before, this system does not work unless people like you are able and willing to serve, and so I want to thank you once again. Throughout the trial, I have admonished you that you could not discuss the case with anyone, including other jurors, and at this point in time, I am relieving you from the admonition. You can speak with anyone about the case from this time forward. I suspect that there's going to be not only the parties that will want to speak with you, but I suspect also the members of the press are going to want to speak with you. And so I'm going to tell you this, I'm telling the members of the media this, and I'm telling the parties and their assistants that it's up to you whether or not you want to speak with anyone. If you don't want to speak with anyone, then you can just head right out the double doors, out the elevators. If there's press outside that want to speak with you, you can just walk past them. Don't let them stop you. If you do want to speak with them, then go ahead and you can wait outside the double doors. We're not going to be speaking with anyone in the courtroom. And if you do speak with someone, please be respectful of the views of any of your other jurors in terms of the deliberations. You can speak with respect to your point of view and how you saw the case. And the other admonition or the other issue with respect to speaking with people is that it's got to be at a reasonable time and place. And so if people start bothering you or if people reach out to you that's inconvenient for you and they continue to do so, let me know and I'll take care of it, okay? All right. All right, with that, once again, I want to thank you. You are now dismissed. Yeah, leave your...